What stood out to you the most?
Well, I guess I would look at the defense summation, and I thought that, he grossly, I think, overstated a lot of the evidence. And I think in doing that, you lose credibility with the jury. I mean, he had to attack Michael Cohen, right? That is something he had to do in this closing.
That's the whole basis of their defense. Of course he would.
He did. But show me, don't tell me. I think a lot of the gimmicks with the gloat and, he's the MVP of liars. Well, if Michael Cohen is the MVP of liars, then Donald Trump was coach of the year, right? This is, you have to do more than that. You have to take us through, show us inconsistencies in his testimony, show us where his testimony doesn't fit with the other evidence. Instead, what Todd Blanche said is Michael Cohen is not corroborated by any evidence. That's just not true. He's corroborated by David Pecker. He's corroborated by an audio recording with Donald Trump. He's corroborated by by call records, by text messages, emails. He is corroborated. And then Todd Blanche then said, well, a lot of other people are lying too. He said the bank statement with the handwritten notes from Alan Weisselberg, he said those contain lies. Stormy Daniels is lying when she said that, she had sex with Donald Trump. He said that David Pecker was lying when he said that he could influence the election with the National Enquirer. He said that's preposterous. He's too sophisticated to think that. That's not what he said on the stand. He said, this was part of the deal. Even the Access Hollywood tape where he said, well, nobody thought that was doomsday. Well, Hope Hicks said, we thought this was a crisis. So when you start picking apart every witness and everybody is lying and you're taking bits and pieces and you're saying, well, believe this witness for one thing, but you can't believe them for things that hurt our client, you lose credibility with the jury. You don't have a coherent narrative. You're picking holes apart in everybody's testimony, and it just kind of felt very disorganized and really not coherent.
Well, GLOAT, greatest liar of all time, is a really clever acronym. Michael Cohen just doesn't fit that description, not when you've got Donald Trump in the room. Hugo, you were in the room today. You have been there for weeks. What stood out to you?
I think at the end of the day, the defense put on a summation that was as good as you were going to get, and I think it was fine. But I thought the DA summation was better because they also rebutted all three main points that Trump's lawyers made. For instance, number one, while Trump's lawyer Todd Blanche was saying, this was Michael Cohen. Cohen created the invoices, and from there, that's why we had all these, potentially or allegedly false checks and ledgers. Well, the DA goes, well, that's fine, but all we have to prove is that Trump caused those false entries to be made. We don't have to show that Trump himself did it. We just have to show that Trump kind of orchestrated the conspiracy. So that was one thing. The second thing was with respect to Todd Blanche saying, well, there was no willful intent to violate election law. Well, the DA came back and said, again, that may be fine, but the moment money changed hands for the benefit of the campaign, there was an illegal campaign contribution, and that is the unlawful means to influence the 2016 election. And everything that Todd Blanche said got rebutted at the start of the prosecution's summations, and I thought that was very key.
Practicality does play a role here, Joyce, and the jury is comprised of humans. What was your take on the length of these arguments? 3 hours and 4 hours and 40 minutes. Any risk of overwhelming the jury with these long closings?
There is that risk. Look, let me just say first off, I'm sympathetic to the lawyers who wanted to make sure that they left nothing unsaid, left nothing on the table. It's been a lengthy case. You really do. This is your only chance to argue the facts to the jury, and I get that. But as a matter of reality, and someone who's tried a lot of cases and is an old trial dog like I am, you understand that juries do consist of people and that their attention span only lasts so long, even when they're a diligent jury, which by all accounts this jury has been. So in many ways, Judge Merchan, by putting no time constraints on the lawyers, didn't force them to make critical decisions about what arguments were most important to present to the jury. That means the lawyers have left some of that work to jurors themselves. But, you know, given the length and the complexity of the case, perhaps this was the only choice that they could live with. As a prosecutor, you certainly don't want to leave unspoken the one argument that could have been the key to the jury's deliberations.
You are not an old trial dog. You're a courtroom queen. Susan, let's remind our audience there were no cameras. There were cameras for O.J., there were cameras for Johnny Depp, but not the first criminal trial against a former president of the United States who could be the next president. How do you think all of this is impacting the American voter?
Yeah, Steph, I think that is really important. I remember some of the very overheated claims at the beginning of this. It was going to change the election dynamic. It was, you know, going to be something that was going to be compelling to people. And I'm sure that people are tuning in to the very extensive trial coverage that has been on television, but it's not the same as seeing and hearing this. I'm sure that America would have been, you know, eyes glued to the television had they witnessed Stormy Daniels, Michael Cohen on the stand. That didn't happen. We are hearing very detailed accounts of these closing arguments, but of course we didn't hear the closing arguments themselves. And, you know, I think that the reality is such a deeply and profoundly divided country, politically speaking. It's a relatively immovable electorate. Right now, there have been very few external events that have in any way changed the dynamics in this campaign between Biden and Trump. And, you know, are we looking at a game changer here one way or the other with the verdict? We'll see. But you know, it's quite early, actually. If the election is going to come down once again to a relatively small number of Americans in a very small number of states, and it's only going to be in late May or early June when a verdict is reached, it's hard to know that this is going to be something that shapes it, but it will go down in the history books one way or the other.
Well, let's talk about a smaller number of Americans, 12 of them. The jury, Hugo, you have seen them. You've seen their faces. You've seen their posture, their body language. This judge seems very bonded with them. He's checking in on them, checking in on their stamina. What is your read on them? We've heard, you know, in reporting almost nothing.
Yeah, you know, famously, it's difficult to read a jury, right? Mm-hmm. But there are at least two jurors who have caught our attention, I think, even collectively as a group. There is one juror, juror number 7, who sits on the side most closest, right, you know, closest to the audience, who has been particularly engaged and has been taking notes at various points. And it's difficult to know what side he might land on. But he has been taking notes, for instance, when Todd Blanche has been up at the lectern. Another juror that was interesting is juror 2. And I don't want to get too much into like the jurors, but juror 2 has been someone who's been making eye contact or seems to have been gazing in the direction of Trump's defense team at various moments. You know, is that indicative that there's sympathy towards the Trump team? Maybe. But maybe it's also like a tease. And, you know, before you deliver that final conviction, you know, kind of staring him down. It's not clear. But there are at least 2 jurors who have been hyper engaged throughout the entirety of this trial, throughout the entirety of the evidence. And I think that's very interesting.
Susan, these are 12 ordinary, anonymous New Yorkers. They're going into a room disconnected from the world. Has Donald Trump, who prides himself and his, you know, cohorts on bullying, has he ever been more powerless to these 12 anonymous New Yorkers?
Well, remember, you know, he doesn't need unanimity. He only needs one of these jurors to object, and there's not going to be a conviction. And in many ways, it seems to me that, you know, his strategy is likely to be the strategy of many defendants in a situation like this, which is to go for a hung jury. And that, of course, Donald Trump would then certainly spin as the greatest victory in the history of the world, undoubtedly, and the greatest vindication after the biggest, you know, most unfair trial that ever was. It's just, it might come down to just one person. Was his lawyer convincing enough to get one person to say no to that? You know, I don't have any insight into what that's going to be, but we have seen Trump himself clearly, I would say, a bit shaken by the experience of the trial. He has been quite belligerent. At the same time, he's been reported, you know, to be essentially forced to be inside the courtroom every day for weeks now. And I think that's for Donald Trump, who is used to doing whatever he wants. Even when he was in the White House, when he was president of the United States, he refused to take a conventional definition of the job and actually show up for work and have meetings. He basically sat all day and watched television and tweeted. Well, this time it was the judge's courtroom and not Donald Trump's rules that we're applying.
Joyce, to Susan's point, it only takes one. Tomorrow, the judge is going to give this jury an hour's worth of instructions. These are not legal experts. How complicated is this for them?
So, you know, this is really a remarkable part of the process, Stephanie, because as you say, typically jurors aren't lawyers. Here we know that two of them are, but hopefully they will honor their obligation along with the other jurors to use only the law as the judge educates it about them. You know, Judge Merchan has made that point several times in recent days, saying it's my job to talk about the law. He cautioned the lawyers this morning before summations began, don't go into the law. That's my job. I'll talk about that. So there are pattern jury instructions. You and I have talked about them before in most jurisdictions, and New York State is one of them, where groups of judges and lawyers spend time accumulating instructions about the law that are affirmed on appeal over and over again. In other words, they're authoritative statements of the law, simplified so jurors can understand them. And Judge Merchan will put them together on all of the relevant legal points, starting with general principles about proof beyond a reasonable doubt, but also talking specifically about the crimes that are charged here. How do you evaluate the presence or absence of witnesses? Are you required to believe witnesses? Can you discount their testimony? There will be legal instructions that will cover all of those situations that will guide the jury's deliberations.